So where we are organizing ourselves with Salvatore, I will make a presentation of product governance and product intervention. I will focus a bit more on product intervention because he will give the ESMA view on this, on product governance, but still I will give just the broad picture. Then he would do his presentation. And then I was asked by Maria Todorov to prepare a kind of practical life examples on product governance, thinking about bankers. I thought there would be many bankers in the room, and I mean bank lawyers. There are many supervisors, but anyway, it will be useful for them also. So I prepared another short presentation where I took, let's say, examples of bad practices in the working of product governance using the FCA as an example because it started earlier, and trying to focus on what, in my view, where do lawyers in banks should really look at the risk. You know, where are the weak points in this new regime where you have to be very careful to try to avoid sanctions. So I try to think a bit, you know, because it's a new regime, it's not yet practiced. What are the weak parts of the chain where really the supervisors and also the bank lawyers, they have to really be very careful when they are being when they are included in the product governance process. Okay, so what happened with this with MiFID II is a game changer because it's a debate between Homo economicus and behavioral finance. So Homo economicus, you know what it is. You learned, all of you, what it is. People are supposed to make rational decisions based on full disclosure. And this is what has been the basis for all securities regulation since the 30s in the US. So everybody is rational, yes, and takes rational decisions based on information. Well, we all know it does not really work like this because humans are humans. So, and also there's not always full information in practice, you know. And now you have this new theory which has developed in the US, which is called behavioral finance, which means people have biases when they take decisions, especially investment decisions. And you have to take into account these biases when you regulate the area. And essentially, you have to, in a sense, protect people against themselves because they will make mistakes, you know, regularly. And therefore, you move from a system which is based on disclosure to a system which is much more interventionist, where you will say to people, sorry guys, but you are not rational, and therefore will induce you, in a sense, you know, to go will nudge you to go in the right direction, or will even prevent you from doing something. We, as the supervisor, the regulator, it's a totally different field, you know. It's fully different. It's not the same thing to say, I want full disclosure, and then you make your decisions, and to say, well, you investors, you are biased, you are making a lot of mistakes, we are going to take decisions for you, essentially, about what is very dangerous or acceptable and so on. It's very, very different. So this is what I would call the game changer in MiFID II. How big is going to be, that's the other issue. But it's a game changer in terms of philosophy. So you have ex-ante control of financial products. So this is the product governance. And then you have ex-post control, which is product intervention, which can take place at the level of national authorities, member states, or at the level of ESMA. And I will develop this. So this new product governance regime is a big change, is a major change, you know. When you take, for instance, inducements, this is just an evolution, basically. You know, inducements are banned, but we knew they were subject to quality enhancement otherwise, and so on. So if you are an independent advisor, it's banned. But it was just evolution, you know, more disclosure, more whatever. Here it's totally different. It's a blank page, basically, which is given to supervisors. So what happened? Well, there were many scandals in many countries, you know, UK, France, Italy, and so on, where people bought products, which were financial products, which were, let's say, toxic for them, and they lost money. So some products were linked to retirements, to loans, to granted capital, structured products, whatever. And there was a kind of outcry, you know, when that this should not have been sold to investors in the first place, especially to retail investors. So it's a change from a liberal approach, disclosure is enough, people are rational, they will not take products which are not good for them, to a more interventionist approach, based on basically authorization, in a sense. It's almost authorization, you know, because you can remove from the market, okay, so it's not ex-ante authorization, But what is the product process, governance process? It's something to make sure that something which comes on the market is not dangerous. The model supervisors have in their mind, you have to understand this clearly, is the drug industry. Before you can sell any drugs, it has to go through a lot of tests, It has to be tested with people. And then if a product has more benefits than risk, the drug has more benefits than risk, it works, then you can start to market it and to sell it to clients. So, and this is the same idea that the EU legislator had in mind and supervisors had in mind to say, well, some products, they are dangerous per se, more or less, or they are very dangerous for retail investors. They should not go to the market, full stop. And in a sense, we'll make sure that they don't do it. Through what? Not ex-ante authorization. It's not in the system. So it's not like the Food and Drug Administration in the US. They don't have control ex-ante, but they have control ex-post. So once it's in the market, we can remove it. But it's a product governance process, so it's designed to make sure that internally, it will not be toxic for those who are the target market. And then at the same time, you have this change, which we have been discussing about the concept, moving from the concept of investor to the concept of consumer. And the change, of course, is not innocent. Why? Because if you're an investor, when you take a decision yourself, based on information, if you're a consumer, then it's a very different world. If you're a consumer, then you will have to be protected by consumer protection agencies who decide what goes on the market or what does not go on the market. So using the term consumer underlines the shift in philosophy, in the regulatory philosophy. So of course then, the legislator, they can mix up a bit between investor, consumer, but this is the point. If you are talking about, if you say that people who buy, investment products are not investors, but they are consumers, then they have to be treated like ordinary consumers, and this means, well, products have to be authorized or subject to stress tests and control and so on. And this also means that supervisors are entitled to get into the process because it's not just disclosure. So this change of philosophy is radical. And so you have to, the dressing has changed, so we're not only speaking about investors, but consumers to justify these powers, which would not be justificable if it was just investors who were acting. So whether, consumer really exists from financial products, I have some doubts anyway, like actually Marcus Lange mentioned, but this has been in the academic thinking also since quite some time. Dave Moloney wrote on this. So anyway, it's a move to merit regulation, but we also have to be honest, We already had merit regulation in Europe, but it was hidden. For instance, you had warnings on prospectuses in some countries, like in France. It was removed by the prospectus directive, then they moved to warning on advertisement, even more. So what is this? It's a merit regulation. It says to people, you want to buy the stock, be careful, it's dangerous. I mean, they don't say it's dangerous, they say they didn't do any, they always lost money, the chair is a crook, they never paid a dividend, they don't plan to pay dividend in the next 10 years. When you read this, you say, okay, thank you, goodbye. So it's a merit regulation, which was already taking place in Europe, and now it's like official, It's official. And you also had public warnings. I mean, ESMA does public warning all the time. You go to a website. National supervisors, you also do public warnings very regularly. So in a sense, it was already existing, but in a more, let's say, informal way, hidden way, because it was against, the homo economicus approach. So there have been some scandals in some countries. UK, for instance, you had a contract called payment protection insurance, which was sold to people who were taking mortgage loans, but in many cases they did not need it. They just did not need it. They were not in a position to need it. And there was huge loss. I mean, they spent huge amounts of money, retail borrowers on this. So this led the FSA at the time to to change its approach. So as usual, the UK changes, and then the others, the kind of moves after the UK. And they were the first to introduce this product intervention regime, which, by the way, leads me to underline that if you want to understand how this is going to work in practice, look at the UK first, because this comes from the UK. In Belgium, you also have problems. There was a bank who had sold Lehman structured products, and then Lehman went bust, and of course people lost everything. This risk was, let's say, not really considered, of course, by anybody at the time. Nobody thought Lehman could go bust. So it was not really a problem of disclosure, but it was a huge issue in Belgium. And at some point, the FSMA, so the Belgian supervisor, they came and they say, well, now we want the banks to stop selling these kind of products. And it was a voluntary prohibition. So I mean, essentially, they were called, in the room, and they say, now you don't sell this anymore, and people say, yes, okay, we don't sell it anymore. But FSMA had no power at the time to do this. But we see this very often in Europe also, it was the case of Atalante, the Italian fund to sell the Italian banks. So people were called for a nice meeting in the room at the Ministry of Finance in Italy, and when they left, they had also left 5 billion euros. They were not allowed to leave the room without leaving the money. Well, anyway, so it was very voluntary, of course. France had the same issue, and there's also been a de facto prohibition on certain products. Okay, so you know the directives, you know everything. ESMA has been up. So you have a huge amount of basically paper of regulation at level 1, level 2, and level 3, and also it's part of it is transsectorial. So this part I will go a bit quickly because Salvatore will deal with this. So essentially, you have two sets of control now. You have the manufacturer of a financial product, so the firm who is creating the product, investment fund, whatever. And then you have a distributor, because as you know, banks, they will sell products, they will sell funds, products which are not always produced by themselves, but which are very competitive. Or sometimes they sell their own products, but of course it's better when they can sell all the products to clients, because they can offer a larger share of assets. So I will go quickly on this. You have a definition of what is a manufacturer. This applies to all financial institutions who have a legal seat in the EU, but also to branches in the EU of third country financial institutions. So by the way, now we have to think in terms of who is a third country. Usually we'll say Switzerland, but in 2 years we have to say UK also. UK, of course, is a huge exporter of financial services. So now we have to, UK will be in this third country category because, my guess, they will not get equivalence regime, of course. So they will be kicked out and considered to be a third country regime. So they will be so it's important now to know what is the status of third country regime. This product governance applies to all investors, retail and non-retail, which makes sense, because if it's toxic, then it's toxic for everybody, not only for the smaller guys. And plus, you had many examples in Europe of huge disasters dealing with so-called sophisticated investors, So let's take, for instance, the municipalities in many countries, They had interest rate swaps, because they wanted to borrow money at a lower rate. And then you had disasters in Italy, in Spain, in France. Some cities went bankrupt because of this. They were taken over by the state, essentially. And they were supposed to be sophisticated. No, this is not true, One of the biggest, so disaster in the US, I mean, you might have heard of the Orange County, in the US in the 90s. No, okay, I was already doing financial regulation at the time, 1994. So they were also speculating. Orange County was the richest county in the US. It's in California, a lot of money. So they were sophisticated. And in Orange County, they had a CFO called Mr. Citron, lemon. And Mr. Citron, he started to play with a few stuff, and then the Federal Reserve increased interest rates, and they went down, and they went bust, So it's not just retail investors who are doing mistakes. Also, so-called sophisticated investors are doing big mistakes, and it's not new. It's not new. So this makes sense to cover them also. Okay, I will leave this to Salvatore. So you have to have this to identify the target market, and you have to evaluate all the time the product. So the idea is essentially the main idea. I don't need to get into details. Salvatore will present the details on this. Is when a bank is thinking about creating a new product, they have to think about who they will sell this product to, basically. It's not like we create a new product and then we put it in the market and we see who buys it. It's we create a product, and then when we create the product, we have to be sure from the start who is going to be the buyer, who should not be the buyer, who should be the one who will be buying this product. So it's you have to think ex ante who is going to be the buyer of your stuff. Well, think about cars, for instance. We're in Germany, so there's a nice tradition. So if you make a car, usually your car manufacturer will say, well, okay, for this type of car, this is this type of target of clients I'm trying to get. And this is the new approach that they have, that banks now have to put into account. And of course, supervisors, they will have to check that the banks, when they offer a new product, they have thought about who is the client, So they offer this product to some clients, not to the others. Yeah, again, if I make a comparison with the Porsche, you will not sell Porsches to people who don't know how to drive or are just starting to drive, So if you produce a Porsche, you want to sell them to people who have already some experience, Otherwise, they have to drive, Minis or whatever. Nothing against the Mini, nice cars, of course. Okay, now also you have control on the distribution chain. So again, the distributor, and more especially the distributor at the point of sale, basically has to duplicate all the duties, Well, it's like when you sell products, when you sell products, you're liable, the producer is liable under EU law, but also the seller. So you can sue the seller, is liable for any product defect, whatever, is liable as if he were the producer himself. So this is exactly the same frame of mind. So if you have your bank selling the stuff, you need to be sure that you are selling to the right person and that you are not. So you need close cooperation with the manufacturer. I will come back to this in a particular example part. So the producer has to do exactly the same job as the manufacturer. So essentially, he has to get the information for the manufacturer. If you are in the same bank group, it's easier. If you're not in the same group, then it becomes more tricky. Think also that if you are selling products which are from the US, for instance, or in the future from the UK, from Switzerland, then these third countries' firms, they will have to be subject also. So you, as the distributor in the EU, you will be forced to ask the Swiss fund maker to apply all this stuff. So probably they would just set up a EU subsidiary and just do it in the EU, I guess, But still, this is something to keep in mind. You will have to, otherwise you will have problems to sell the funds. Okay, now I turn to the ex post control, so the product intervention. So the idea is that only products who are not dangerous or too dangerous will go on the market, especially for retail investors, but not only for retail investors. But sometimes, what happens in practice? When you look at some of the catastrophes which took place in this, mis-selling of products, when the product is designed, it looks very safe. That's the problem, It looks very safe. Because, for instance, it implies that it's safe unless, interest rates skyrocket. And the banker will tell you, well, the probability of interest rates skyrocketing is very low. Or, for instance, you take a loan which is in a foreign currency. This has happened a lot in Central Europe, So in Poland, for instance, in Hungary. So people will borrow money in Swiss francs, for instance. Make loans in Swiss francs. Why? Because the interest rate on the Swiss franc was very low. And the bankers will say, well, Swiss francs, you always go down, yes. But then you got the crisis, and Swiss francs become, a safe currency, and it skyrockets. What happens? Well, Hungarians, they are broke. In Poland, we had huge problems. Maybe also in the Czech Republic, I don't know. But it was a disaster. But at the time of, let's say, contracting the loan, it didn't look dangerous. It didn't look dangerous. That's the issue. But then, after 3 years, your loan is 10 years, 15 years, 20 years, then it becomes extremely dangerous, and people and borrowers go bust. So when you realize this, ex post, even if you didn't make any mistake from the start, so you block toxic products which are toxic from the start, which is something good. Product didn't look toxic, but then becomes toxic. Then you have to be able to stop it. So this is why you have ex post control. First, you miss something which was toxic from the start, and then you realize it's toxic, then you stop. Or it's being sold to wrong people, so then you stop it. Or product didn't look dangerous, so you authorize it. I mean, it was not blocked, it was okay, but then it becomes dangerous because financial markets changes, and then it becomes extremely dangerous. Okay, you have two types of control, two lines of defenses, so say, but one line is the most important. National authorities, the member states, and then the ESMA. Well, when you look at the single market, I mean, essentially, you have 28 different markets. Okay, some countries are very international. Luxembourg, of course, funds will be sold all over Europe. But you have many different behavior, in each country. So in Italy, they buy sovereign bonds. In France also, it's not a good idea, but anyway, that's what they do. In other countries, they will buy more stocks. In others, they will buy some investment funds. I mean, each market, is rather different. In France, for instance, you could not borrow money really in foreign currency, and so there were only few people who were close to the border of Switzerland who were caught with this. So, now the loophole has been closed, but it's not in French tradition. Some people borrow, for instance, at fixed rates in some countries, other at variable rates. I mean, Europe is not united on this, so it's very different. So the real line of defense, I would say, is the national member states and the national authorities, of course, because the market are still very much national. Okay, you have different tools. So Article 69 of MiFID provides that a national authority can suspend financial instruments and structured deposits. So structured deposits are a type of investment which is linked to some financial variables, such as interest rates and so on, and which are being sold to investors as an alternative to deposits. Because what's the main issue we're facing? It's ZIRP, or NIRP, even worse. Zero interest rate policy, or negative interest rate policy. Central banks are doing this policy, basically, to save the euro, but the result is people get zero, or almost nothing on their income. So they're looking for alternatives. This is rational, it's rational behavior. And there are not so many alternatives. So when the banker comes and says, look, why don't you invest into this stuff, we bring 3%, they say, thank you. So they invest into structured deposit, they don't look too risky, they invest into other products, which could be more risky. But otherwise, people were usually happy in Europe with investing at 5% in sovereign bonds or in whatever. But we live in different times, and people are being, let's say, kicked out of the deposits area to a more, let's say, a bit risky investments. But so many people don't want to go into the stock market. So you have to. So they go into some stuff, some hybrid stuff also, and because they are fearful of the stocks market. Okay, so what can national supervisor do? And this is a new power. This is a new power. And by the way, in some countries, this is already into force because some countries, they anticipated. Well, to start with, UK. UK started with this. So in some countries, this is already the law. So national authority can prohibit or restrict the distribution in its own member state or in the other member states, so they can block the passport, essentially, of certain types of financial instruments, or, which is much wider, certain types of financial activity or practice. So it's not the instrument itself, but the way it's being sold or used or whatever. So it gives a lot of flexibility. There are conditions required in MiFIR. There's quite a list of conditions, actually. So let's look at them. I mean, is the power easy to use or difficult to use? Well, for the national authority to be allowed to restrict the sale or to prohibit the sale, they must be, because this is, I underline this because this is, where you have the, for security supervisors, this is the most important point, a significant investor protection concern. So, for instance, many people are affected, or they are affected with, or there are big losses in some areas. And I would say it's not a hard hurdle, I mean, when you have a big investor concern, you know it. So then I would say it would be not too difficult to say, look, we have a big issue here, we have to fix this. And the way to fix this is to stop the sale or to restrict the sale. Then you have the derivatives, okay. But then B is more problematic. So the EU existing regulatory requirements under EU law do not sufficiently address the risk, and the issue will not be better addressed by improved supervision or enforcement. So this is more tricky, because in order to block, you need to show that EU law is not enough, and that enforcing EU law will not be enough. And this is a bit more tricky because when you look at EU law, 500 pages of legislation or regulation, well, if this is not enough, I don't know what would be enough. And most of the time, it's issue of mis-selling, you know. People are being sold stuff which is not adequate for them. So it would be interesting to see, you know, how it works in practice, you know. If, I mean, because the investment firm who is selling this will say, look, you are overstepping, you know. It's overreaching. You should have, it's just an issue of enforcement. But of course, if you're a supervisor, what do you want to do? You know, you see you have a disaster of mis-selling of a certain product in your country. And you have two buttons, you know. One button says, I'm sending 100 people on the field, you know, and making sure there's no more mis-selling. And one button says, I stop the selling immediately just by fiat order. What are you going to do? What is the most effective as a supervisor? I see. Yes. To send 100 people in the field and try to sit down to be sure that everything is okay? No, this will not happen. Just for the reason that they cannot, supervisors usually don't have 100 people ready like this to go in the field. So supervisors will be, you know, biased to use the power in this direction. But it's not so easy to do, you know, because essentially it's enforcement issues. So we'll see how it works in practice. But I'm sure it will be used. Then you have criteria. I love this. Yeah. This is awful. So you have 22 criteria, if I counted correctly, you know. And I think it was something like 65. I didn't put it because I didn't want someone to say, no, sorry, it's 64, 66. 65 sub-criteria about whether or not, you know, you can use this power. Oh, this is great. My personal view is, you know, the more you have criteria, the more you have freedom to do whatever you want, essentially. So, because you have so many doors which are open to you that essentially it's I would say it's a blank check. So the real issue is whether increased enforcement will not be enough to do this. But by the way, you know, when I think about it, I mean, the supervisor could say, well, increased enforcement could do it, but I don't have people to do it. Therefore, I cannot do it. And therefore, I have to block. This could be a good argument, maybe, in court, to say, well, increased enforcement will do it, will stop the problem, but it will be long, it will be slow, and I not have enough people to do it. So this could fly in court, maybe. Okay, you have to avoid, of course, hurting the single market, not targeting one country specifically. You have to consult, so you have to inform the other authorities. That makes sense, because you have a passport. You have to inform ESMA, and ESMA will publish a public opinion on whether it's good or not. So ESMA will be, let's say, checking that it's not an abuse, essentially. So this has been used in some countries under national legislation. So the UK, for instance, they started to prohibit in 2014 COCOs, contingent convertibles, selling this to retail investors. I have to say this was the right move. COCOs should not be sold to retail investors. I don't even think they should be sold to institutional investors, you know. But at least they are supposed to know what they are doing. So you know all what is COCOs. You know, it's under the Basel regulation. You have loss absorbing capital, which will be decreased, transformed from debt to equity, in case prudential ratios are not respected. And this will happen without any resolution. So it's a smooth process. So basically, you're buying a debt from a bank, which yields, let's say, 7%, for instance. There have been some COCOs around 7%. And as long as the bank is doing OK, then you get your 7%. If the bank does not respect its prudential ratio anymore, then you become the proud owner of the bank, because your bond is being turned into equity, which, by the way, creates another problem because some of the holders of this, they can be investment funds, which are bond funds, and then suddenly they end up being what? Well, they end up being shareholders, which is not allowed under the UCITS regime. So they also have to sell. So you get a double sanction for these guys. So it's very dangerous. This should not be sold to retail investors. Why? Well, because retail investors, can they read a bank balance sheet? Can they know the risk? I don't want to be hard on EBA, but what was the result of a stress test, Many banks, some banks failed just after, succeeding in the stress test. Even the ECB, is the ECB so good, to spot who is going to be a problem? Not so sure. So even the supervisor is not able to assess the risk. How can you expect this from a retail investor? It does not make any sense. So it was a good idea. Germany has prohibited another type of product, which is close to cocoa, called credit-linked notes. So this was done by the BaFin, and they stopped it at the point when many people were buying it. So as long as it was a niche market, they let it alone. But when it started to be big, they say it's too dangerous. People don't understand. Yes. So they cut the system. Okay, ESMA now. Well, you have Article 9 of ESMA. And ESMA, as a supervisor, in a sense, they have one goal, A securities supervisor has essentially one real goal. All the rest is nice, but it's not so important. There's just one yardstick by which they have to be judged. And this yardstick is investor protection. Did you protect investors correctly? That's all. The rest is not really it's additional. It's not the main business. So of course, ESMA is full of, regulation is full of investor protection issues. So ESMA has to monitor new risk. They may issue warnings, which we have done so far. And they even have in regulation a committee on financial innovation. So to spot, new trends and try eventually to act at the ESMA level if it's necessary. So ESMA is also in charge of detecting what could go wrong. Because one of the issues which happened, for instance, not so much in the securities era, but in the banking, but it's the same reasoning, You have one country which is basically reckless in its supervision. And all the others, they say, look, what you're doing here is extremely dangerous. And the supervisors say, well, no, sorry, but my model tells me that it's okay. It will not be a problem. But of course, if a bubble bursts in this country, who is going to pay the bill at the end? The other country, because you have the euro. So this is contempting the others. So you need to have, let's say, some ESMA pressure to say to some countries, look, this cannot carry on, because for whatever reason, it's dangerous, So ESMA has temporary intervention powers, so they cannot block finalists, so they are kind of second line of defense. They are subject to the same conditions, plus other special conditions, such as there's lack or inaction by the national supervisor. So the national supervisor, sometime in good faith, it happened before 2008. I will not mention them, but some supervisors, they say, sorry, I don't have a real estate bubble in my country. Yeah, come on. And then it burst. And then everybody has to make a nice check for this country. Great. And they could have been in good faith. I don't say they went bad faith. So this can happen also in the securities era. The member states, the authorities say, well, look, it's a successful product, Why should I stop it? It's nice. It has not created issues. But others, might say, no, look, this is going to blow out in 1 or 2 years, so stop it. Okay. ESMA has not used, of course, they cannot use this power yet, but what did they do so far? I think they have been doing something very effective, and here we are about legal certainty and issues of soft law. Because when you look at ESMA, soft law is not soft law, of course. Soft law is hard law. ESMA soft law is hard law. So what will they do? Well, what they've done so far is exactly like national supervisors. They do investor warning. You have an issue which has popped up in 3-4 countries, basically. So they will say, it's no point to have 3 and 4 warnings. Let's have one ESMA warning, and then everybody will follow up on this. So, and they have been targeting retail investors. So CFDs, contract for differences, binary options, I don't even know what it is. Rolling spot forex, no idea what it is also. And these are dangerous products sold in certain countries. And because they are sold from one country to investors in other countries. So we had the example of Cyprus, this morning, who had registered some firms doing this kind of stuff. And this can be dealt at the EU level, because essentially it will make just avoid fragmentation of the market. Then there was the issue where I've been working a lot when I was at the stakeholder group at ESMA, which is self-placement, and this has been a disaster. A clear failure of supervision. So self-placement is the fact for a bank, or saving bank or whatever, to sell its own products to its depositors. So its own securities, its own shares, its own hybrid capital. And people have been burned by this, Spain, to start with. Then he moved to Portugal. Well, I call this the Spanish disease, sorry. But he started in Spain with Bankia, the Caras, and many others. Then he ended up through the Tago, he went up in Lisbon, where you have Banco Espirito Santo, and now you have Italy, which is full of these problems. And what is it? It's a failure of supervision. People bought this stuff, so they are being asked by the banker to show up, for a meeting, and the guy says, okay, you have deposits, they yield you 0. I suggest you invest into a bond, or what we present as a bond of my bank, which will yield 5%. Is it safe? It's like a deposit. No, it's a lie, of course. And then suddenly people invest, overinvest, whatever, and then they lose everything. It's not acceptable. It's a social disaster, in addition. People take it to the street. And then, of course, you have to indemnify them at the end of the day. So ESMA, at the stakeholder group, we are pushing on ESMA to act on this. But this was mostly a national member state issue. And I'm very pleased to say that in June 2016, basically self-placement was prohibited through an interpretation, not a guideline, not a new rule, but through a mere interpretation of MiFID 1, actually. Now, to me, it's a de facto ban. Okay, to conclude, what can I say? Well, now you have a new power, if you look at product intervention as supervisor. This power is to prohibit financial products, even when they're outside. But you have to be extremely careful as supervisors when you will be using this power. Because if this ex post control become a kind of de facto ex ante control, then you will end up being exactly like in the US, the Food and Drug Administration. The livelihood of banks will depend on whether or not you will allow products to be on the market. And if the livelihood of banks, so if you hold let's say, the profitability of banks in your hand, it's a matter of life or death for the banks. Which means what? They need to control the decision process. And you end up with risk of losing the independence of a securities supervisor, because the pressure will be huge. And there have been huge problems in the US at the FDA, where the FDA was controlled by the industry, which is not the case of securities supervisors today. Securities supervisors are not controlled by the industry. But if the industry thinks, oh, because of this power that we have received, that they have received, they can control, whether or not I'm going to survive or not survive, then it's a matter of life or death, and they will play hardball in a sense. They will try to control the supervisor. This would be a disaster, of course. Would be a disaster. If the power is used, in extreme cases where really it's obvious there was a problem, then it's okay. But then if it turns into a kind of ex ante control system, it would be a disaster for the investors and for the supervisors also. Okay, now, so far this power has been used quite in some countries, and of course you face the risk of market fragmentation. So one country allows, the other does not allow. So we have a single market, we're supposed to have a capital market union, and we end up with 4, 5, 6 different regimes, with everybody with their own specialty, So structured products, prohibited in France, in Belgium, to retail investors, in UK, but with differences, of course. Great. Do we really want this in Europe? No, we should move toward a more harmonized approach. ESMA has not used it too much. We cannot use it actually now, but it will come. I will urge cautious, I wish ESMA to be cautious also, unless you have a risk of market fragmentation. So, if it's an issue which pops up in 4, 5, 6 countries, it's better to stop it everywhere than to stop it only in 4 or 5 countries with 4 or 5 different rules, because we need to build a single market, you know. So now, and the last point on the product governance process, this will now be presented by Salvatore. It's something which banks have to be very keen to work on, because it's very bureaucratic, it's very costly, but plus, what are the risks here? You have high risk of sanctions. If something goes wrong, well, the supervisor will come on the banks and say, well, maybe the product was not so unsafe or whatever, it's not easy, but they will find some formalistic, you know, violation, and they will slam you with a huge fine, you know. So it's a minefield, basically, for a new minefield for banks. First, it's costly to put into place, plus the supervisors, if they feel there's any problem, they will not hesitate, of course, to put big fines on this. So this is really a very dangerous area for the bank. So product intervention, in a sense, is a dangerous area for these supervisors, but product governance is a dangerous area, I would say, for the banks. Thank you.